Thank you very much for coming. As many of you know, my name is Kenneth Grad. I'm assistant professor here at Robson Hall. And it's my distinct pleasure to welcome you to the 16th Annual DeLloyd J. Guth Visiting Lecture in Legal History. Professor Guth, who is now enjoying a well-deserved retirement, had a long and distinguished career as a university teacher and scholar. And he was known for his insightful scholarship and profound dedication to his students. And Professor Guth's specialty, indeed his passion, was legal history, and we are honored to continue this tradition in his honor. The Annual DeLloyd J. Guth Lecture Series has brought many outstanding legal scholars to our campus, including this year's speaker, Dr. Simon Wallace, whom we are privileged to have here today. Before introducing Professor Wallace, I would like to begin with the land acknowledgements. The University of Manitoba campuses and research spaces are located on original lands of Anishinaabe, Ininiwak, Anisininewak, Dakota Oyate, Dene, and Inuit, and on the national homeland of the Red River Métis. The University of Manitoba recognizes that the treaties signed on these lands are a lifelong, enduring relationship, and we are dedicated to upholding their spirit and intent. We acknowledge the harms and mistakes of the past and the present. And with this understanding, we commit to supporting Indigenous excellence through active reconciliation, meaningful change, and the creation of an environment where everyone can thrive. Our collaboration with Indigenous communities is grounded in respect and reciprocity, and this guides how we move forward as an institution. And it's important to recognize that the harms referenced in this acknowledgement are not only historical, but also ongoing, and that the law has played a powerful role in shaping these realities. Of course, legal frameworks have often structured who is included within the protections and benefits of citizenship and who is excluded from them. And understanding how these legal structures developed and how they have been used makes legal history an essential tool for confronting past injustices and avoiding, or at least mitigating, future harm. With that framing in mind, it is my pleasure to introduce our speaker, Dr. Simon Wallace, who will speak on a topic of manifest historical and contemporary relevance. Dr. Wallace is assistant professor at the Lincoln Alexander School of Law at Toronto Metropolitan University. A former refugee lawyer, his research examines Canadian immigration, exclusion, and citizenship law. As a historian, Professor Wallace studies the development of Canadian immigration law in the early 20th century. As an empirical legal scholar, he also uses computational methods to organize and analyze large data sets of immigration law, uncovering new insights about how legal systems evolve over time. Dr. Wallace completed his PhD at Osgoode Hall Law School and is the recipient of the Peter Oliver Prize in Canadian Legal History. We are privileged to welcome him today. Please join me in welcoming Dr. Simon Wallace.
Perfect, thank you. What Kenny didn't mention is we actually graduated at the exact same time and got to sit together through a very, very long and hot convocation together a year ago, 2 years ago, I'm not quite sure. Thanks so much for having me. I'm very excited to be here, and I'm very excited to talk about this topic, which is a surprising and I think new history of Canadian citizenship law. Let me begin, though, by just orienting us a little bit to the problem, and then I want to tell you about what I think my contribution is. So for the purposes of this talk, I'm focused on the development of Canadian citizenship. Citizenship is obviously a very challenged and complicated concept, but I have my eye on two things, and I want you to have your eye on two things. The first is just the fact that people call themselves citizens. So if I was to do a very quick and not entirely accurate, but very quick history of the modern history of the international law of citizenship, it would look something like this. Around the French and the American Revolution, you start to get citizens. And then throughout the 19th century, it tips up a little bit. And then around World War I, the number of citizens, the number of people who define their relationship to a state as one is between state and citizenship, really accelerates after World War I, through World War II, and then through decolonization. Put differently, citizenship is a new, modern 20th century phenomenon. It happens slowly at first, and then all of a sudden. I'm interested, though, in this period, this slowly at first period, because one of the things that I found as an immigration researcher, a surprising thing, is that in 1910, the Parliament defined Canadian citizen in an Immigration Act. And my question is why? Why is it that in this time before citizenship spread dramatically throughout the world, that Canada saw fit to describe who a citizen was and thought it was something important to do before most of the world did? That's the question. And so what should you have your eye on? One is what I already told you, the number of people and the number of states who are defining their relationship in terms of citizenship. And then two, I want to focus on one particular part of citizenship. Citizenship is a thick concept. It can describe voting rights, it can describe social citizenship. But one of the most durable and consistent features of modern citizenship law relates to movement, right? So as a Canadian citizen, as an American citizen, as an Indian citizen, as a Chinese citizen, we all enjoy one right, which is to return to our country of citizenship. It's a very stable part of modern citizenship law. I'm going to argue it's one of the more new parts, and it's the part of citizenship law which drove Canada well in advance of everyone else to begin to develop a definition of citizenship, to begin to control who could and could not cross a border into Canada. Okay. And let me just tell you my argument now so I don't surprise anyone. And you can see whether or not I scaffold it and give you the evidence. My argument is that what makes Canadian citizenship really interesting is not that we were the first, not that Canada was the first country to have citizenship, but that it was functionally the second. That what makes Canadian citizenship interesting is that we, when I say we, I mean the Canadian state, was forced into citizenship because of its relationship with the American state. And it was diplomatic and administrative American legal activities which compelled Canada to develop a definition of citizenship. So it's our proximity to the United States, our proximity to the American legal project that prompted Canada to develop a definition of Canadian citizenship in 1910, which then becomes more interesting for us when we try to understand the big explosion of citizenship that's going to occur after World War I. Perhaps, and this is one of the suggestions of this talk, what led Canada to define Canadian citizenship and to embrace Canadian citizenship in 1910 are some of the factors that led other countries around the world to do it as well. Okay, one more prefatory remark, just to help you place this talk in the general historiography of Canadian citizenship. The standard story is that Canadian citizenship doesn't develop until after World War II. Paul Martin Sr. Shepherds through a bill after World War II that really establishes the modern framework of Canadian citizenship, the modern thick definition of Canadian citizenship. And that's a very familiar story for many colonial republics, for many countries around the world. And so you can see this as kind of a rejoinder to that history. Something definitely happens after World War II, but if you accept my argument by the end of this talk, what you're going to be convinced of is that there is an impulse beginning at the very beginning of the 20th century, which is pushing Canada and pushing similar states to develop an idea of what a citizen is and to develop an idea of what Canadian citizenship is. Okay, I hope that's interesting, because if it's not interesting, you're stuck with me for an hour. Okay. Let's begin, though, in sort of the right before this 1910 period. Before 1910, before the passage of this Immigration Act, anyone who was in Canada who had a relationship with the Canadian state was classified as a British subject. A few things to know about being a British subject. The most important thing is that if you were a British subject, your relationship to the Crown was indelible. I think I've got all the syllables there, indelible. What that means is that you could not terminate your British subjectness. Once a British subject, always a British subject, up until the point that the Crown disclaims you. and the Crown didn't disclaim people. Becoming a British subject was similarly sort of a matter of Crown prerogative, that some people would become subjects through conquest, through imperial activities, and by sort of grand politics, they would become British subjects. To be a British subject did not mean being a citizen in the modern sense. So a subject had, just as citizens do, a subject had rights and responsibilities. There was not a notion that there is today, and the idea that I want to be tracking, that to be a British subject meant that you had specific rights of movement around the world. You did in a certain way, but that's not what being a British subject meant. Being a British subject meant that you owed duties to the Crown. You could be prosecuted for treason, for things like that. And similarly, you enjoyed certain rights. Most of these rights are what we would categorize today as civil rights: the right to own property, the right to hold public office, the right to vote in some elections. But to be a British subject, it was sort of like being a fish in the water. It wasn't something that people thought much about. It wasn't terribly contested. I skipped a slide, but we won't worry about it. That's significant, though, when we contrast with American citizenship. To be an American citizen meant something entirely different, and it meant something different by the early 19th century. So after the American Revolution, after the French Revolution, one thing that happened is there was a new idea of how it was that individuals would relate to these new types of political entities that weren't just imperial entities. At first, the idea of who it was who was going to be an American citizen was a little unclear. But by the early 19th century, the criteria to be an American citizen developed. So the first criteria for the first half of the 19th century was you had to be a free white person. And the second criteria was that you had to meet certain residency requirements. So you had to spend X many years in the United States. You had to apply to be a citizen. There was a cooling off period. You had to have someone sponsor you, and then you would swear that you were an American citizen. What becomes interesting, though, throughout the 19th century is through the Civil War, through the War of 1812, you have on the North American continent two different political ideas of the relationship to the states in North America developing right next to each other. And I'm sure more if we look to other political entities. And as these two ideas developed, diplomatic tensions started to emerge. So the most obvious, or chronologically the most obvious one, is that during the War of 1812, it's going to become a source of tension between the British imperial authorities and the American authorities about who's on whose side, who can be prosecuted for some things. During the Civil War, similarly, it's going to become a source of tension between the British imperial authorities and both the North and the South. Who is entitled to British imperial diplomatic protection? Many people who wanted to avoid conscription into northern armies went to the British embassy and said, I want your diplomatic protection. I'm a British subject, not an American citizen. I shouldn't be prosecuted. I shouldn't be conscripted for that. But then what really happened and really was an important moment was in the late 1860s. Fenianism became a significant moment. And so for those of you who don't know, the Fenians were people who believed in Irish republicanism, and there were Fenian cross-border raids from the United States into Canada. And there was also all sorts of Fenian political activity in Ireland. After the Civil War, when some Fenians were arrested in Ireland, some of them claimed America's diplomatic protection. I fought in the Civil War. I'm an American citizen. It shouldn't be possible for the British to prosecute me for my participation in the Fenian political movement, and I should be able to count on my Republican brothers in the United States to help me out. This was, when American diplomats started to get engaged, kind of shocking to the British system, because there wasn't much of an idea that there could be a dual loyalties or an American citizen in Europe, or that someone could ever terminate their British subject, their relationship to the crown as a British subject. So at the late 1860s, there was a really important sort of negotiation between the American authorities and the British imperial authorities, which led to the passage in the British Imperial Parliament of the Naturalization Act, that for the first time allowed people to disclaim their British subjectness, I'm making up words on the spot, their political status as a British subject in order to become an American citizen. Okay, so just to pause there, where are we? And we're about to turn to Canada in a second. We're about to turn to the subject of this talk. Where we are going into the 19th century is that people in British North America and what will become Canada, they were British subjects. They weren't Canadian citizens. But to be a British subject was beginning to change in the 19th century. If we went into the 19th century and to be a British subject meant that you had a permanent and unbreakable relationship with the crown, by 1870, it was possible to terminate that relationship with the crown when you became an American citizen. There's some fluidity. There's some liberalism creeping into the international sort of law about how people relate to different political entities. With me so far? It's interesting? Yeah. Good, good, very interesting, good, because you're with me for another 45 minutes. Treaty 1. So Treaty 1 has an interesting role or an interesting spot in this story. So Treaty 1 is negotiated and signed in 1871. The purpose of Treaty 1, one of the purposes of Treaty 1, is to reflect the desire of Her Majesty to open up to settlement and immigration a tract of country bounded and described as hereinafter mentioned. The purpose of the treaties, one of the purposes of the treaties, is to encourage European immigration to settle the West. That's one of the purposes. 1871, by 1873, Canada establishes the Ministry of the Interior. The Ministry of the Interior very early on has two core functions. The first is immigration, and the second is Indian Affairs. These two functions, and you can really sort of see these two functions in the original treaty. And I don't have the evidence to back it up, but I'm pretty sure that it was the fact of the treaties that led to the establishment of the Ministry of the Interior. And this relationship is going to become interesting in a little bit. From about 1873 to July 1900, I forgot the exact date, but it's a day in July 1900, Canada had an extremely liberal immigration policy. More than having an extremely liberal immigration policy, it lacked the police apparatus to have anything but a liberal immigration policy. So there was, of course, the Chinese Exclusion Acts, there were the head taxes, there were all sorts of measures that Canada was taking to try to control who could and could not immigrate to Canada. But unlike the United States, through beginning in the 1880s and really developing in the 1890s, when you came to a Canadian port, mostly from Europe, but a little bit to Vancouver, but mostly from Europe, you were not greeted by an immigration police officer, as you were today. Instead, you got off the boat and a steamship agent or someone with one of the train companies would help facilitate your journey to wherever it is that you were going. This drove the Americans wild throughout the 1890s and early 1900s for a very simple and practical reason. They looked at the Canadian ports, they looked at Canadian immigration, and they saw that there was just this easy mechanism to thwart the operation of American immigration policing. People could, they thought, instead of traveling to New York and then going off to their destination, circumvent the entire process of immigration control by going through Montreal, taking a train over, and dipping down south through Winnipeg to wherever they wanted to go. And so throughout the 1890s, there are all sorts of extensive diplomatic efforts to try to get Canada to join a continental-wide immigration exclusion program, to align Canadian laws with American laws, and to build up an immigration police force such that no matter where you arrived in North America, you would be inspected and monitored and potentially repelled and deported back to where you came, and not be able to thwart one country's immigration laws by just dipping across the border and walking around. For a long time, Canada was disinterested in joining that immigration exclusion project. But that changed in 1900, and it changed for a very kind of specific and sort of discrete and recognizable historical phenomena, which was widespread anti-Semitism amongst Canadian state officials. I'm not going to belabor this point too much, and we're going to talk a little bit about it in immigration law tomorrow. But in 1899, Mount Etna erupts. And when Mount Etna erupts, it coincides with an eruption of Mount Vesuvius, famous for the lost city of wait, is it? No, it's Pompeii, not lost city of Atlantis. I'm mixing up. I'm reading stories to my kids right now, and I'm like all of my Pompeii. One thing that happens when these two eruptions happen simultaneously is the skies over the Balkans are clouded and the crops fail. Particularly the crops fail in Romania today, Romania then, and the economy crashes. Already a profoundly anti-Semitic society, and in the context of the economic crash, anti-Semitism spikes even further. And a movement of Jews begins to walk to Canadian ports, and they call themselves the Walkers. So they walk to European ports destined for Canada, and they call themselves the Walkers because it just so happens that this eruption and the collapse of the Romanian economy coincides with the first major effort to spread immigration propaganda throughout, Canadian immigration propaganda throughout Europe. Come to the West, there's free land. And thousands of Jews started to walk to Canadian ports. And it was at that moment when the Canadian authorities learned of this early refugee migration to Canada that the Canadian authorities, they didn't pick up the phone, they sent the telegraph to the American authorities and were like, okay, we're in. We're in because we all of a sudden we're interested in waylaying this particular movement. And from that moment on, there's no looking back. The first detention, they call them immigration hospitals, but they were detention facilities, begin to be built in Canada. Anyone know who Dr. Thomas Bryce is? Wrote A National Crime, which is famous for being the document in 1907 that blew the whistle on mass death in residential schools. He and Professor Sean Carleton is maybe the main scholar doing work on Dr. Bryce. The reason he's in government to even be able to write that report is he's hired in 1903 to be Canada's first, and this was his title, Chief Deportation Officer. And he was building up these immigration hospitals in order to be able to detain and deport people. Okay, so let's just recapitulate for a second. Throughout the 19th century, one was a British subject. The relationship, the proximity to the American Republic meant that what it meant to be a British subject came under diplomatic stress. And there was a major modification to what it meant to be a British subject in the 1870s, where people were able to change their allegiances and stop being a British subject by becoming an American citizen. Functionally, from 1870 through the 1880s, through the 1890s, this would not have been something that would have been felt by most people immigrating to Canada because there was no immigration police officer there to examine citizenship, to wonder about anything. But by 1900, any port along the eastern seaboard, whether it's an American port or a Canadian port, the probability of encountering an immigration police officer, they didn't call them that, immigration officers, but an immigration officer equipped with police powers to inspect, detain, and potentially deport, increases dramatically. And the apparatus, the immigration policing apparatus, in order to be able to do that policing operation effectively, just expands throughout the 1900s. And then things get weird, okay? So now, so the story with talks and slides is you shouldn't have lots of words, but I'm going to break this rule and everything that comes. But if it gets boring, I've told Amar and Kenny that we're going to do a dramatic reading on the next slide, so we'll see. Okay, This is the American, so it's an act to regulate the immigration of aliens into the United States, 1903, more colloquially known as the Anarchist Exclusion Act. The main function of this law was to make a new category of inadmissibility, to say that anarchists weren't welcome in the United States and were potentially deportable. One thing, though, that happened right off the top is that there was a duty, a head tax, on every single immigrant who came to the United States before then. But in 1903, they raised it, the head tax, to $2, but carved out an exception. They said, if you are a citizen of the United States or a citizen of the Dominion of Canada, the Republic of Cuba, or the Republic of Mexico, you don't have to pay the $2 head tax. This was for very simple reasons, that if you are an American politician, you want to enable a measure of trade and commerce across the border, and you don't want people who are just moving goods back and forth to have to pay $2 every single time. So they exempt citizens of Canada. Does anyone hear the problem? There's no such thing yet as a citizen of Canada. Okay, should we do a dramatic reading? I can do it. I can do it. You want to do it? You want to do it? No? Okay, I got it. Not that people didn't know. So this is from the debates in the House of Representatives. And so Mr. Powers of Maine is talking about this provision about exempting Canadians, and he says, I cannot understand the meaning of it. Mr. Shattuck, then the gentleman cannot understand the English language. Mr. Powers of Maine, the term citizen of Canada is used. I was not aware that there is any such term as citizen of Canada. If you will change that to resident of Canada. Shattuck, it is subjects of the division. Powers, they are subjects of Great Britain and residents of Canada. If the gentleman will change that to residents of Canada, excepting all persons residing in Canada, I think the bill may not be subject to so much objection as it is now. Shattuck, I will say to the gentleman that long before he and I became statesmen, this was the law as it is now. Powers, I think not, and I find this interesting, I think not. There is no such law that I have ever had my attention called to, and I have been a collector of customs along the frontier for some years and had something to do with these matters. So power, I mean, it's like a different democracy back then, right? You know, you can really feel like there are people, they are elected, they go to Washington however many times, they still have their jobs, they're doing things. And he's saying, like, I am on the border, and I can just tell you, these Canadians who I collect customs from, they're not calling themselves citizens. And then here's my favorite part. Powers, I believe that if you were to apply this to persons who cross the border as they do up in the vicinity of my home, as they are doing in my own place, instead of having it read citizen of Canada, for there really is nothing of that kind, it should be residents of Canada. And this is where it gets good. Barthold, offer the amendment. I will, perhaps, when the time comes. Now is the time. After this amendment has been adopted, I may offer an amendment to change the word citizen in line 5 to resident. Offer it now, offer it now. And then Mr. Adams, who I don't know who he is, says we should not do that because if we change this to resident instead of citizen, it'll mean anyone will just be able to circumvent this head tax by going to Canada, declaring themselves a resident, and they won't pay the tax. So the amendment fails. It's a fascinating sort of pluralistic moment of legal orders, where the Americans just have it in their head, well, we're citizens, therefore citizenship makes sense. But there's this understanding that the Canadian state doesn't have such an understanding. And very quickly, we run into problems. And so this is out of Winnipeg. What happened here, and I won't read the full thing except for the last part. What began to happen, what this article suggests, but then what many other communications suggest as well, is that through other negotiations that the Canadian state had made with the American state, it became acceptable for American immigration officers, just as happens in Canadian airports today, but for American officers to come to, say, Winnipeg train stations, Halifax ports, Montreal ports, and do their immigration work in Canada. And so here is a story, protests against US officials of an American officer who met a woman who was, she lived in Winnipeg. Her father was ill in Duluth and she was going to go visit her father. And she just got on the train to go to Duluth. And he said, prove to me you're a Canadian citizen. She was like, I don't know what you're talking about. And eventually, he extracted $2 from her, so she would be able to visit her father across the border in Duluth. And this caused all sorts of political tension. And here's the part I want to, so the people complain about it, they're complaining about this idea that there'll be anyone preventing them from crossing the border between Canada and the United States. Even Russian barbarity sinks to insignificance compared to this. It's like the line that's circulating in Canada. Like, we know what's happening in Tsarist Russia. You think that's repression? These Americans demanding $2 from us to cross the border, removing us from trains. This is so odious to what we do, which for me is a very interesting moment to pause when we think about how this is developing. 1904, we have a border suddenly beginning to be felt. And for the people who live here, and for the people who live in Duluth, the idea that there could be American or Canadian officials interfering with your ability to travel is immediately offensive, immediately recognized as illiberal, and immediately recognized as something that Canadian officials ought to intervene in to prevent from happening. Again, we're not going to read this, but this is, I think, an extremely consequential letter in the history of immigration and citizenship law in Canada. This is a man, similar sort of thing happened. He had to pay the $2, and he was like, it's a shock to me that I'm not a Canadian citizen because I've spent 20 years or something in Canada, and the Americans don't think I'm a Canadian citizen. And he wrote to the Canadian government and said, could you intercede on my behalf because I want my $2 back. I want my $2. It's not an insignificant amount of money. And the Canadians sort of go back and forth. And then for the law students in the room, this is an interesting letter. Eventually, the head of the immigration department writes to the Department of Justice and says, I just need a legal opinion about what a Canadian citizen is. And every now and then, and the students will probably recognize this, every now and then, some professor will come up or some old member of the profession will be like, the practice of law has not fundamentally changed in 100 years. It's the same. This is the memo. He just wrote it by hand on it and sent it back. I think it's extraordinary. This is the Deputy Attorney General. The Canadian state was so small back then. The Deputy Attorney General himself wrote by hand the memo. And I can't read his handwriting, and neither could they. So fortunately, they transcribed it. And so Mr. Clark is the American, and so this is the Deputy Attorney General. Mr. Clark very naturally refers to a citizen of Canada in the same sense that he would refer to a citizen of the United States or a citizen of France. By such words, that is, he uses the term as we do, a British subject. There is no citizen of Canada in that sense. This is how that legal opinion begins. So 1903 Anarchist Exclusion Act, we have a head tax. It exempts Canadian citizens. That forces a legal question. Well, who is a Canadian citizen recognized by American law when the Canadians have no such concept? And the Deputy Attorney General resolves it by saying, okay, well, I'm just going to give him an answer. Mr. Clark's next question is, what is required of a British subject to make him a citizen of Canada? The answer to this question is nothing but to take up his permanent residence in Canada, which at the time, in the context of this narrow legal issue, makes a tremendous amount of sense. It makes a tremendous amount of sense because if you are a Canadian government official and you want to be protecting the rights of Canadians, whatever that may be, you want the broadest possible definition of Canadian citizenship in order to exempt as many people as possible from having to pay the head tax every time they cross the border. So it's very savvy. It's very savvy. Anyone who lives permanently in Canada is a Canadian. What could go wrong? That's called foreboding. Thank you for laughing. Okay. So that's 1905. So Theodore Roosevelt is president now, and this is from his 1905 State of the Union address. It's very Trumpian. And so State of the Unions back then, they didn't actually go and address Congress. They just sort of wrote these speeches and sent them out. But he talks a little bit about immigration. In actual practice, it has proved so difficult to enforce the migration laws where long stretches of frontier marked by an imaginary line, that's the Trumpian part, right? Marked by an imaginary line alone intervene between us and our neighbors, that I recommend that no immigrants be allowed to come in from Canada and Mexico, save natives of the two countries themselves. 1905. A few things I want to point out here. So for those of you studying the Safe Third Country Agreement, you can sort of see its lineage descends deep, deep into Canadian history. But there is this idea that exists still in 1905, that even though we've got the Canadians, and to a lesser extent the Mexican state, to join in the project of continental immigration exclusion, this huge line makes practical enforcement a huge problem. And so he's calling for this idea to say that only Canadian citizens and Mexican citizens should ever be allowed to cross in to the United States through a land border, forcing all other people, all immigrants, through the ports where they can be inspected. And what he also calls for is, it seems to me to be wise that there should be an international conference held to deal with this question of immigration. And some are, but the bottom line here, and the sentiment you can feel emanating from the president, and much of this was, I think, driven by the president's office, was that one goal, one objective of the American state should be to draw other countries in to our understanding of immigration law, that they should be aligning their laws with ours so that we can all be able to enforce immigration law more effectively. And we should be leveraging diplomacy in order to convince other countries to be doing that with us. And just remember, when you compare to that Manitoba Free Press, thank you. Manitoba Free Press article, just how radical this would have landed. And the Americans by now are a bit more accustomed to the idea that there are citizens and your citizenship is going to control your ability to move in and out of countries. But to an international audience, this was truly a radical proposition. So if the story so far is the first impulse to define Canadian citizenship comes in relation to the head tax, and and there is an interest then in defining Canadian citizenship so broadly as to exempt as many people who are in the state or the territory of Canada to be able to avoid the head tax. This very quickly becomes problematic for Canada. Up until this point, Canadians were unaccustomed, really, to the idea that people would be deported from within a country and not at a port. Deportation is, when you think about the mechanics of it, a very difficult endeavor, right? You've got to take someone, you got to, especially if this is the 19th century, early 20th century, find a ship, you got to convince the ship to take them back. Most ships just go back and forth between 2 or 3 places. It would be very challenging to have deportations today where we deport people to all sorts of countries in the world just by flying them through connecting flights. And so are we familiar with the continuous journey regulation, the Komagata Maroon? It's a thing that happened that we won't talk about today. But by about 1906, 1907, the American immigration policing operation has become sophisticated and muscular enough that they are starting to do more inland deportations. They're saying, okay, there's a 3-year waiting period, and if someone can commit some sorts of misconduct, they're deportable. And by about 1907, there are enough immigration officers, there's enough of an apparatus that they're identifying people and they're trying to deport them. If you are an American official and you need to deport someone who's been in the United States for 1, 2, or 3 years, what you hope for is that you can deport them to Canada or to Mexico, simply for fiscal reasons. You can, often maybe you're going to try to lean on a steamship company to have them take someone back for free, but sometimes you're going to have to pay. There's going to be a challenge of maybe forcibly seizing someone's body and putting them onto the ship. Easiest thing you can do is to develop some way of just getting someone across the border into Canada. Unfortunately for the Americans at that time, the Canadians had given them this extraordinary legal theory. The Americans have it in their mind, and this would have been a complete shock to the Canadians, that to be a citizen meant that you were allowed to return to your country. Right? It's a very American idea at this time. And the Americans have that idea, and then they also have this memo from the Canadian Department of Justice saying anyone who was ever a permanent resident of Canada, who took up their permanent residence of Canada, is a Canadian citizen. And so the Americans were like, oh, ipso facto, anyone who's ever lived in Canada is a Canadian citizen, and we can just start deporting people to Canada. So here's an example, and this is going to add a new interesting wrinkle to our legal analysis. So as you're going to see, the sort of intersecting axes here are mental health, race, and gender across many of these cases. So a black woman who was born in Ontario, and she lived there for somewhere between the first 15 and 20 years of her life, married an American man. One provision of the treaty that was negotiated in the late 1860s was that citizenship or subjectness for women is going to follow the citizenship of their husbands. So as soon as they marry someone, they become an American citizen. And so the legal theory here is she became an American citizen because she married Alfred Barnett. He's working as on a Pullman dining car. But then after she entered the asylum, so after there was some sort of alleged psychotic break, he divorced her. And the Americans developed this theory that as soon as the divorce happened, she loses her American citizenship. And so they write to the Canadians and they're like, fantastic news, we're going to return one of your citizens, which was a surprise to the Canadian authorities. A surprise for a number of reasons. One, just to get the letter, just to discover that there's this legal theory which authorizes the return of of Canadian citizens, even though they had become Americans and they lost it because of divorce. And is also going to be surprising for the fiscal implications. If you are in the immigration office, what you see is you're sending someone who is incarcerated lawfully in an asylum, and they're probably going to have to be lawfully incarcerated in an asylum in Canada now. And it looks, and what the memo shows, it looks to the Canadians like the Americans are trying to deport their fiscal obligations to citizens to Canada. And they're trying to offload certain fiscal obligations onto Canada. Here's another case, another asylum one. A patient was admitted to the Protestant Hospital for the Insane as a private patient, July 22nd, 1906. On June 3rd, 1907, she was discharged. She had been in Canada only for a few days before she was sent to the hospital. So sorry, it's a little confusing, but had been in Canada for a few days before she was sent to the hospital in 1906, having come from the United States. And similar sort of thing, a brief relationship with Canada, and the Americans said, okay, we're going to send you back to Canada. It's a surprise to her. There are letters from her. She was very surprised to find out that she was a Canadian citizen. She wanted to go back to Europe. But it was a surprise to the Canadian officials as well, that we're going to have to receive people who spent just a few days in Canada because they are now Canadian citizens. And then a very interesting case. The Americans wanted to deport Joseph Needham as a public charge in the state of Massachusetts because he had leprosy. He was born in Trinidad and had transited to the United States by coming through Canada and then going down, and had spent maybe a week or two living in Canada. And the American legal theory was, well, he took up his residence while he was in Canada, and as a British subject of Trinidad who took up his residence, who was never lawfully admitted to the States because we don't accept people with leprosy, we can send him back to Canada. And this caused something of a diplomatic spat between the Americans and the Canadians. But just to say it, and it's going to be familiar to all of us now, if you're the Canadian immigration authorities compared to the American immigration authorities, you're the junior partner. You're very much the junior partner. So in every one of these cases, I shouldn't say every one, in the vast majority of cases that I review, ultimately the Canadians just sort of acquiesce. They acquiesce to what the Americans want. Partly though, partly for diplomatic reasons, but partly also because they just don't feel like they have a legal theory with which to resist the American claims about Canadian citizenship. But eventually it becomes time to develop their own legal theory. Right, and so like here you can see it. The Canadians were just complaining about all these cases, and the Americans write back and they're like, I don't know why you're complaining. I've got your letter of December 12th, 1905, in which the official states that what is required of a British subject to make him a citizen of Canada, nothing is necessary but for him to take up permanent residence. The Americans just keep throwing this memo back in the Canadian faces every time the Canadians seek to object, saying like, we don't know this person, they were only here for a few days or what have you. And so eventually it reaches the point that we get legislative action. And this is going to, I hope, make quite a bit of sense. The reason for the legislative action and the reason for that 1910 law is that Canada needed to develop a legal theory of citizenship that superseded the one that the Department of Justice had just sort of issued in a cavalier way that the Americans were running with. And in order to be able to control who the Americans could and could not deport into Canada, we get our first definition of Canadian citizenship. Canadian citizen means a person born in Canada, a British subject who is Canadian domicile, a person naturalized under the laws of Canada who has not subsequently become an alien or lost Canadian domicile. And a British subject who has Canadian domicile is essentially a British subject who has lived continuously and permanently in Canada for 3 years, is the definition they settle on. And then there's a proviso that says, for the purpose of this act, a woman who has not been landed in Canada shall not be held to have acquired Canadian citizenship by virtue of her husband. So we see this American theory, we see this common law theory that if you are a woman, your citizenship is automatically going to follow your husband and can be terminated by divorces and by other things. And the Canadians just arrest that idea by saying, well, we're only going to recognize people as women as having Canadian citizenship at the moment of landing, when they actually come across the border. We're not going to allow extra legal events to determine who is or is not a Canadian citizen. What do you think the Americans do when the law gets passed? Sorry? They lose their minds and they go to London. It becomes an imperial thing. It becomes an imperial thing. And within a month or two of it being passed, there are diplomatic cables going between Washington and London, complaining about a bunch of things, but the Bureau of Immigration advises me that the authorities of the Dominion declined to receive from us, under orders of deportation, anyone not a native-born Canadian who has left that country for ours. Later, they say, you know what, we've even stopped trying to deport people because since the receipt of the above interpretations of your new Immigration Act, I've taken it for granted that it would be useless to ask your department to authorize the return of persons who became citizens of Canada by naturalization. The Canadians, how am I doing for time? We have to be out of here. Yeah, let me wrap up at this point. Yeah. For the Canadians were never excited about the idea of citizenship. They never felt like this was something they needed. They felt like it was something that was forced upon them. And they then made one last play. Once they had citizenship, once they had the attention of all the diplomats, they said, you know what if we all just kind of like abandon this idea? We don't need to be Canadian citizens. We don't need to be American citizens. How about We enter into diplomatic negotiations, and we say across the Canadian-American border, if we need to deport someone, we can deport them to whichever country either they lived in for a year or were sort of last in. And eventually the Americans just sort of say no to that. Okay, so let me recapitulate. What's the theory? What's the idea here? The idea is that in this story of slowly at first, then all of a sudden, there are all sorts of things which explain why citizenship has become such a dominant and consistent and in some ways uncontested part of the international legal order. There is an idea now. We're all citizens of some place and can return to that place. Citizenship is many other things, but that core idea is not really contested by anyone now. The suggestion here, the suggestion of the evidence that I found and my suggestion to you, is one of the things that was driving the expansion of citizenship globally, and that we see here in Canada. What makes it interesting is not that it was first, but that it was second, is that relationships with the American immigration state, the American deportation state, compelled Canada to develop its own theory of citizenship in order to be able to interface with the American immigration system. And the suggestion I want to make to you is that this will explain partly the rise of citizenship, the actions of a global hegemon beginning to assert itself throughout the 20th century, and will really explain some of the reasons that citizenship has become such a dominant feature of the international legal order now. I look forward to talking with you about it.